Welcome, everybody. We're just going to give a few more minutes to let some more people in. Hello to everyone that is arriving. We're just giving a few more minutes, letting people in, and we'll go ahead and get started. Thank you for attending. All right. Welcome, everyone, to Services for Independent Living's Fair Housing, Equal Enjoyment webinar. Today's webinar has been brought to you by Services for Independent Living and the Fair Housing Center for Rights and Research. My name is India Jones. I am the Community Services Manager over here at Services for Independent Living, and I will also be your webinar facilitator for the day. Just want to get into a few housekeeping rules. All participants will be muted during the webinar. Please place any questions that you may have into the question box. We will attempt to answer them at the end of this webinar. A recording will be available on our website at www.sil-ohio.org. We will have a satisfaction survey that will pop up at the very end of this webinar. Please fill it out, you guys. This is how we get our feedback on how we're doing, what other topics you guys may be interested in hearing about, and so on and so forth. If you would like to receive 1 CEU credit for attendance, and this is only offered to licensed social workers, licensed independent social workers, and social work assistants, please select yes on that particular question on the survey that I told you will pop up at the very end of this webinar. Today's speaker is Tanesha Hunter. She is the Director of Education Outreach at the Fair Housing Center for Rights and Research. We are very happy to have her today. Tanesha, I'm going to go ahead and give you the floor. And you can take it from there.
Great. Thank you so much, India, for that introduction. And it is such a pleasure to be here today to celebrate April, which is Fair Housing Month. We're going to go ahead and get started. I'm going to share a PowerPoint presentation. Okay, and then I just want to make sure, is there a way to make sure that my screen is, can folks see my screen?
Yes, we can see it.
Okay, perfect. Okay, and today with me, I will have Kayla Paul, who is our Education and Outreach Intern at the Fair Housing Center. She is going to start us off with this presentation. And so I just want to note a disclaimer before we get started. Neither Kayla or I are attorneys, so for any specific legal questions, please consult an attorney. This information is for informational purposes only. So I did just want to bring that disclaimer and make you all aware. And so with that, I will go ahead and let Kayla get started.
All right, thank you, Tanesha. So let's dive right in. So the Fair Housing Research Center is a nonprofit agency that promotes equal opportunity and healthy race relations in Northeast Ohio. The Fair Housing Center was founded in 1983 with a goal in place to expand housing opportunities to the residents of Greater Cleveland. Our mission is to protect and expand fair housing rights eliminate housing discrimination, and promote integrated communities. And we carry out our mission by providing a variety of services, which include advocacy, in which we provide assistance to those who may have experienced discrimination in housing, as well as imposing and enforcing fair housing laws. We do complaint investigation, in which advocates are available to assist housing discrimination victims free of cost in the complaint process. We enforce fair housing by monitoring rental sales, homeowners insurance, and leasing agencies for discriminatory practices. Our research team produces a variety of reports, maps, and other publications examining fair housing and fair lending issues in the region. Our education team readily conducts informational sessions for a variety of housing market professionals, case in point today. And we engage in the community by ensuring residents are aware of their rights under the fair housing laws. Okay, so fair housing is a civil right protected by federal, state, and local laws, and Tanesha will get into the protected classes a little later on. So the goals of the Fair Housing Act is to eliminate housing discrimination, as well as promote residential integration and undo the effects of prior discriminatory policies and practices. Okay, so why is fair housing important? Where you live matters, right? So housing impacts access to quality schools, access to healthy foods, job opportunities, as well as access to quality, adequate health care. It also impacts life outcomes, upward mobility, as well as exposure to environmental hazards such as lead paint. And I'll pass it.
Thank you. Thank you so much, Kayla. I appreciate that introduction. So now let's talk about a little bit more about fair housing. Okay. So again, April is Fair Housing Month because on April 11th, 1968, the Fair Housing Act was passed. And when the Fair Housing Act was first passed, there were only 4 protected classes. Those 4 protected classes included race, color, religion, and national origin. Disability didn't get added in as a protected class until 20 years later. And we'll talk about protected classes in just a little bit here. But first, let's talk a little bit about what property is covered. So under federal fair housing law, there are some exemptions for properties that are covered, such as single family homes and owner-occupied multifamily dwellings. However, Ohio's law does not recognize those exemptions. So in the state of Ohio, just about all properties are covered under fair housing, under our fair housing statute. And so what that might include, that's homes, apartments, condos, manufactured and mobile homes, nursing homes and assisted living facilities, residential recovery housing, transitional housing, dorm rooms, extended stay hotels, timeshares, and even vacant land intended for residential construction, all covered under fair housing law. So now that we know a little bit about what property is covered, let's talk about the protected classes. So again, on the federal level in 1968, race, color, national origin, and religion were added as the protected classes under federal fair housing. And so race is, you know, how someone identifies their race, whether they identify as Black or white. Color can be intra-race, so that could even be perhaps a Black person who is light-skinned discriminating against a Black person who is dark-skinned. National origin includes the country where a person was born and maybe even where their ancestors are from. Religion, sex, we'll talk about in a couple other slides because there's some specific protections under the basis of sex, familial status, and then disability. Those last 3 we'll get a little bit more in depth about because they can be a little bit confusing. They just have a little bit more information that I can provide to you about it. So that's on the federal level. Then in Ohio, ancestry, which is a little bit broader than national origin, is covered, as well as military status. And then in Cuyahoga County in 2018, sexual orientation and gender identity were included. And so it's very important to know what's covered as far as fair housing in your local laws. There can be some additional protected classes. So local fair housing ordinances may even include further, again, sexual orientation, gender identity, age, marital status, parental status, source of income, and that's how a person pays their rent. So whether or not a person uses, Social Security disability, whether they use a housing choice voucher or any federally subsidized vouchers to pay for their housing. Creed, ethnic group, occupation, physical characteristics, and then even association with the protected class as well. So protection on the basis of sex, this covers a few different things. So of course, one, sex, whether or not you identify as male or female, sexual orientation and gender identity. This is a recent added protection on the basis of sex on the federal level. President Biden just recently signed Executive Order 13988. And what that does is that it is allowing HUD to now formally implement his executive order to conclude that the Fair Housing Act prohibits sex discrimination because of sexual orientation and gender identity. And this really affirms the Supreme Court case Bostick versus Clayton County, which in employment also affirmed that sex discrimination includes sexual orientation and gender identity. Then while it's not explicitly listed on the federal level, also included as a protected class on the basis of sex is one's status as a victim of domestic violence, and then also sexual harassment. Familial status. This has a very specific definition. So all of the other protected classes are regardless of, right? Regardless of your race, regardless of your religion. However, familial status has a very specific definition. It's the presence of children 18 and under living with a parent, legal custodian, or a designee, being pregnant, in the process of securing legal custody of a person under 18, and also includes foster parenting and adoptions. And then disability also has a very specific definition under fair housing. So a person is protected as a person with a disability under fair housing law if they meet one or more of the following conditions. So physical and or mental impairment, which substantially limits one or more major life activities. And that may include, seeing, hearing, walking, cooking, things of that nature. Record of having such impairment. And so a record of having such impairment is having a history of or being misclassified as having either a mental or physical impairment that substantially limits one or more major life activities. Also being regarded as having such impairment. So if someone is how someone perceives you, if someone perceives you to have a disability, you could be protected under fair housing law as well. And also includes people associated with or residing with a person meeting these definitions. So which disabilities are covered? So some quick examples: a chronic mental illness, hearing, mobility, and visual impairments, cancer, AIDS, HIV, developmental disabilities, and then alcoholism or past drug abuse. The Fair Housing Act, however, does not protect current illegal drug users, and then anyone who poses a direct threat to the health and safety of others or causes substantial physical damage to the property. And a lot of the times we'll get questions about medical marijuana use as far as current illegal drug users. And there's conflicting information, and cases have not yet to be seen here in Ohio. But as you all know, in the state of Ohio, medical marijuana use is allowed. However, on the federal level, it's still a Schedule I drug. And so it's yet to be seen as far as what fair housing cases would look like if someone was trying to use their medical marijuana in a home and a housing provider wouldn't allow it. So now we'll talk about some additional protections for people with disabilities. So starting in the 1970s, many groups, including persons with disabilities, racial minority groups, and women, were all fighting for policy reform to address, discrimination in many different aspects, including housing. And so there were a lot of laws and Supreme Court decisions that have really advanced rights for persons with disabilities throughout the years. And so starting in 1973, we saw Section 504 of the Rehabilitation Act, and just in general, the Rehabilitation Act. Then, as I stated previously, in 1988, the Fair Housing Act was amended to include disability. And then in 1990, we saw the ADA Act being signed, the Americans with Disability Act. And then in 1999, we saw the landmark Supreme Court decision in Olmstead versus LC, which is a ruling that requires states to eliminate unnecessary segregation of persons with disabilities and to ensure that persons with disabilities receive service in the most integrated setting appropriate to their needs. And so often we'll see that these laws, overlap in their coverage, but some housing may be covered by only one of these laws, while other housing may be subject to maybe 2 or 3 or even all of them. And so again, the Fair Housing Act was amended in 1988 and specifies that people with disabilities must be granted reasonable accommodations and reasonable modifications in order to afford them equal enjoyment of the dwelling. So we'll talk about reasonable accommodations and reasonable modifications. And so reasonable modification equals a change in policy. Reasonable modification equals a physical change. And then also, when the Fair Housing Act was amended, there were new construction requirements. So 7 accessibility features on new construction. So reasonable accommodation. Again, reasonable accommodation is the change in policies and procedures that govern the residence. The accommodation must be related to the person's disability, cannot cause an undue financial and administrative burden, and I want to emphasize financial and administrative burden to the housing provider, cannot be a fundamental alteration of the normal services or provision. So cannot fundamentally be so far off of what is regularly provided to the housing by the housing provider. The housing provider must grant the accommodation if it meets these criteria, right? So if a person needs a reasonable accommodation, and I'll give some examples of what a reasonable accommodation is, as long as it's related to that person's disability and is not causing the housing provider undue financial and administrative burden, and it's not causing a fundamental alteration of the normal services or provision to that housing provider, then the housing provider must grant that reasonable accommodation, okay? So some examples of reasonable accommodations, allowing a service animal despite a no pet policy, right? Informing others, whether that be family, social workers, of new policies related to the house, allowing non-tenants to use a laundry facility, moving from one unit to another without a fee, reserve parking spaces, allowing for a live-in aid, and then changing the rent due date. Say, for instance, I receive, disability income on the 3rd Wednesday of the month, but my rent due date is on the 1st, allowing a change in rent due date so that it falls on that same day that I receive my check. And then, using the Ohio Relay Service. A little bit further into service assistance animals, just because it's a hot topic, and typically we see a lot of cases that are related to service assistance animals. No matter where you are in the United States, likely disability is the #1 complaint received from individuals on being discriminated against in housing under the Fair Housing Act. So the Americans with Disability ADA and the Fair Housing Act do not have the same definition of service animals. Fair housing law allows service animals for reasonable accommodations in housing and offer a broader definition of service animal. So no training requirement for or having an animal be defined in the Fair Housing Act. And then people with disabilities can need a service animal for several different reasons. Okay, my screen just, okay. Sorry, I'm not used to using GoToWebinar and something just popped up and I don't know how to get rid of it. Hold on 1 second. Okay. Okay, I apologize about that. Service or, and so for definition, service or assistance animals help with specific tasks, such as guiding an individual who is visually impaired, fetching items or alerting a hearing impaired person to sounds. And then emotional support animals help relieve depression, anxiety, and stress-induced pain. And so because, emotional support animals can be a variety of animals, right? A person can have an emotional support ferret or an emotional support bird. And so for that reason, training is not required for service or emotional support animals under the Fair Housing Act. So more on caregivers in fair housing. So a live-in aid, and again, this is an example of a reasonable accommodation as well. A live-in aid is defined as a person who resides with one or more elderly persons, near elderly persons, or persons with disabilities who is determined to be essential to the care and well-being of the person and would not be living in the unit except to provide the necessary supportive services. And so still must comply with occupancy standards. So for example, if you're living in an apartment and there's already 4 other people living in that apartment and the occupancy standard is, 4 people, you having a live-in aid come in to be that 5th person wouldn't be allowed because it would go against the occupancy standard for that apartment. Reasonable modifications. Again, this is a physical change to the property to allow a person full enjoyment of the premises. And that can be to the interior of one's own unit and then also common areas as well. If, for example, the lobby. These are typically at a tenant's own expense. And I'll talk a little bit more about under what circumstances a person may not have to pay for their own reasonable modification. But typically these are at the tenant's own expense. A person can request at any time, a person doesn't have to wait until they've been at a property 6 months to request a reasonable modification. They don't have to wait any particular time to request it. They can request whenever the need comes up, they can make a reasonable modification request. A landlord can require proof of covered disability, and the modification must be related to the disability. However, when talking about a housing provider or landlord requiring proof of covered disability, there still cannot be any unlawful increase to the nature or extent of a person's disability, right? So if I am making a reasonable modification request, excuse me. If I am making a reasonable modification request and my landlord, if it's not readily apparent why I need that reasonable modification request, my landlord or housing provider can ask for proof of covered disability, meaning that I would have to provide a letter stating that I have this disability that substantially limits one or more major life activities, and this particular reasonable modification will allow me to enjoy the dwelling equally. That's it. I don't have to say what my specific diagnosis is. I can provide that information if I'm comfortable with it, but if I'm not comfortable with providing my specific diagnosis, I do not have to. A landlord only needs to know that there is a covered disability that relates to this reasonable modification request. That's it. And we'll talk a little bit more about that in just a minute. So some examples of reasonable modification requests, widening doorways, installing grab bars, lowering heights of kitchen cabinets, installing a ramp, installing automatic water faucet shutoffs, installing or removing carpeting, lowering or raising heights of switches, outlets, or thermostats, and then installing lever door handles. So a couple things to know about reasonable modifications. A housing provider can require a tenant to return the interior area of the unit to original condition, but not common areas, right? So, and then a reasonable escrow requirement is okay for restoration of the unit. So say, for instance, a reasonable modification request is made, and it's something that the landlord believes will take a lot of money to be able to restore the unit back to its original condition. A housing provider can ask for a reasonable escrow account to be established, where money will be set aside each month until the end of tenancy, or until a set dollar amount is in that account, to ensure that when the person ends their tenancy with that housing provider, that they're able to pay for the restoration. So the process for requesting reasonable accommodations and reasonable modifications, again, a tenant can make the request at any time. You will make sure you want to document all reasonable accommodation and modification requests, including any verbal requests. Put it in the email, send it as a text message, with some sort of paper trail to note when the request was first made. A housing provider must respond in a timely manner. In a lot of cases, we've seen a lot in case law where this is the issue and the reason for complaints of discrimination. For example, there was a case recently in California where a person had put in a reasonable modification request for grab bars, and the housing provider just kind of threw it in with a mix of regular complaints and, or excuse me, not complaints, regular requests for maintenance. And so time went on, and the person never received their grab bars. And of course, this person needs those grab bars in order to be able to enjoy their dwelling equally, to be able to, get in and out of the tub and things of that nature. And so the housing provider a lawsuit was then filed against that housing provider for not responding in a timely manner. So there's no specific time frame. You may hear sometimes that a landlord has to respond within 30 days. No, it has to be a timely manner, and it has to be on a case by case, because what you're asking for, you could need that very next day in order to be able to enjoy your dwelling equally. So it must respond in a timely manner. A housing provider can ask for documentation if the disability is not known, apparent, or if connection to disability is unclear. Again, they can ask for documentation. However, and that documentation can be provided by medical provider, social service worker, mental health professional, or someone with intimate knowledge of a person's disability. The letter is not required to disclose the diagnosis, nature, or extent of disability, but can include information the consumer feels comfortable disclosing. Again, letter only needs to state that the person has a covered disability that impacts one or more major life activities, and that the requested reasonable accommodation or reasonable modification is needed due to that disability. So now a little bit about new construction requirements. So after March 13th, 1991, any construction built after that has to have these new 7 required accessibility features. And the accessibility features include an accessible entrance on an accessible route. So that means, a continuous unobstructed path connecting accessible elements and spaces in a building. Public and common use areas. This might include that the areas included in the rooms, space, or elements inside of a building are made available for the use of residents of a building, or that guests, that allows for areas that might include hallways, lounges, lobbies, laundry rooms, mail rooms. All of those have to be usable and accessible. Usable doors. All the doors designed to allow passage into and within all premises, and are sufficiently wide enough to allow passage by the usage of someone with a wheelchair. And then accessible route into and through the unit. And again, this is, the accessible route must pass through, any main entry door, and again, be able to be used by a wheelchair. Light switches, electrical outlets, thermostats, all premises within the dwelling must contain, light switches, electrical outlets, and thermostats, and any other environmental controls in accessible locations. Reinforced walls for the grab bars. Again, if you're requesting for a grab bar to be installed, you want to make sure it's not going through the wall. And then usable kitchens and bathrooms. So dwellings must contain usable kitchens and bathrooms so that an individual who perhaps maybe uses a wheelchair can maneuver about that space. And again, so this is for all new construction built for occupancy after March 13th, 1991. I know that in Northeast Ohio, we have a very older housing stock. I think the median age for housing in Cuyahoga County was almost upwards to 100 years. So we don't have a lot of new construction in Cuyahoga County. And so, that's where reasonable modifications come into play. But anything built after March 13th, 1991 has to have these 7 required accessibility features. Before I get to section 504, I talked a little bit about earlier on reasonable modifications requests. So in a circumstance where you might find a dwelling built after March 13th, 1991 that doesn't contain one of these 7 required accessibility features, and in that instance, you maybe need to request a reasonable modification request in order to compensate for that. Under that circumstance, that housing provider would then have to pay for that reasonable modification. But that's, again, in a circumstance where you have a building that's built after March 1991 that doesn't have one of these 7 required accessibility features. Under that circumstance, a person would be able, a housing provider would have to pay for the reasonable modification. Now, section 504. So I talked a little bit earlier about section 504 when I talked about some of the different laws that have come about that's really advanced disability rights throughout the years. And so, section 504 of the 1973 Rehabilitation Act was the first disability civil rights law to be enacted in the United States. It prohibits discrimination against people with disabilities and programs that receive federal financial assistance, and really set the stage for the enactment of the Americans with Disabilities Act. However, even though that's great, section 504 was signed in 1973, there was the 504 sit-ins that occurred in 1977, I think around April of 1977, and these were disability rights protests that began because in 1977, 4 years later, the regulations hadn't been implemented yet for section 504. So 4 years after it was signed, regulations hadn't been implemented. And so people with disabilities and the disability community occupied federal buildings in the United States in order to really push the issuance of those long delayed regulations regarding section 504. And prior to, the ADA being signed in 1990, section 504 was really the most, important disability rights legislation in the United States. So section 504 states that no otherwise qualified individual with a disability in the United States is defined in section, in the section of that title shall solely by reason of his or her disability be excluded from participation in, be denied the benefits of, or subjected to discrimination under any program or activity receiving federal financial assistance, or under any program or activity conducted by any executive agency or by the United States Postal Service. So section 504 requires HUD enforce the right of individuals to live in federally subsidized housing or participate in any federally assisted program free from discrimination on the basis of disability. Also covers employment discrimination based on disability, and requires HUD and HUD assisted entities to make reasonable accommodations for known physical or mental limitations of an employee or qualified applicant. It covers all HUD programs except for its mortgage insurance and loan guarantee programs. So Section 504 prohibits excluding or not providing people with disabilities access to participate in any service, program, or activity, requiring a person with a disability to accept a different or lesser service, accept service separate from others without disabilities, pay an added fee for their service, meet different eligibility requirements, or forego any service or amenity available to others. Section 504 requires that programs and services be conducted in the most integrated setting appropriate. Housing provided to individuals with disabilities should not be separate or unnecessarily segregated. And then accessible units in a single elevator building should be located throughout the building and not just on the first floor. In projects having multiple buildings, accessible units also should be interspersed throughout these buildings and not clustered together. So for example, in housing for seniors and people with disabilities, for example, persons with mental disabilities or any other disability may not be segregated to one specific wing or floor in one building. And then also requires that when a uniform federal accessibility standards unit for a mobility impaired person becomes available for occupancy, a provider must offer the unit to a qualified individual with disabilities currently residing in a non-accessible unit in the same project or comparable projects under common control who requires the accessible features. And if there is no such persons currently residing in the recipient's projects, the recipient shall then offer the unit to the next available qualified individual with disabilities on its waiting list, provided that the person requires the accessibility features of the unit. The recipient shall skip over applicants who do not require the accessibility features on the waiting list to offer the unit to the next qualified individual who does. And again, this is in federally subsidized housing. And so a little bit more about, I talked about reasonable modifications under what circumstances a person should pay. So the Fair Housing Act requires private landlords to permit but not pay for reasonable modifications. So again, if the reasonable modification request, meets the definitions that we talked about earlier, it doesn't provide an undue financial and administrative burden, then a housing provider has to permit but does not necessarily have to pay for reasonable modifications. However, recipients of federal financial assistance are subject to Section 504 and are required to both permit and pay for reasonable modifications. So in those circumstances, the housing provider would have to pay for reasonable modifications. One caveat to that is that private landlords who accept housing choice vouchers at their properties are not considered recipients of federal financial assistance. The voucher follows the person and not the home. So in those circumstances, if a housing choice voucher recipient needs a reasonable modification, then they would actually have to pay for it. It would be at their expense. And a big question that we often get is, if a person is responsible for paying for reasonable modifications, are there resources in order to be able to do that? And I know that SEAL has some information on resources available if a person needs some assistance with paying some reasonable modifications. So now that we talked about the sort of properties that are covered under fair housing law, we talked about protected classes, and then we really got in depth about additional protections for people with disabilities. Now we're going to talk about prohibited acts. So what sort of actions taking place by housing providers are prohibited under fair housing law? So what is housing discrimination? So under fair housing law, it's the refusal to sell, rent, negotiate, or otherwise make unavailable or deny a dwelling. So, excuse me. So for example, with refusing to rent, a housing provider, is refusing to show a person an apartment because they notice maybe an accessible parking placard in their car. Also discriminate in the terms, conditions, or privileges of sale or rental of a dwelling or in the provision or services or facilities. And so an example of that might be, maybe not allowing a person with a seizure disorder to use recreation facilities. Making, print, or publish any notice, statement, or ad indicating a preference or limitation based on a protected class. So again, that's, if you're looking at different housing rental advertisements and you see something that maybe says, no SSDI accepted, or, no persons with motorized wheelchairs, or something of that nature. Misrepresenting availability. So, a person comes to an apartment to the leasing office and they're in a wheelchair, and they ask about apartments, and the housing provider tells them we don't have anything available. Then a person walks in behind them and asks about the availability of apartments, and they tell them, oh, 5 apartments are available, misrepresenting availability. Then again, denying a reasonable accommodation or modification request. And I just want to emphasize the importance of that. Is that housing providers are permitted to permit reasonable accommodation and modification requests. Again, as long as they are not causing that undue and administrative burden or substantially altering the provision of services, then they are permitted to permit those requests. Then, intimidating, threatening, interfering with, or otherwise retaliating against a person who is exercising their fair housing rights. And we see this often where, maybe a person tries to put in a request for a reasonable modification or accommodation, and the housing provider doesn't understand the process, doesn't understand their obligation. They get nervous or they get scared or whatever the case is. And then they tell the prospective tenant or the tenant that, oh, well, maybe you're on a month-to-month lease, so I'm just going to, put you out, or, I'm going to evict you because I don't want to deal with this request. That is definitely a violation of the Fair Housing Act. Or, for example, a person tries to exercise and make a complaint against a person because they feel like they've been discriminated against, and then the landlord turns around and evicts them, or tries to charge them extra, or whatever the case is. So retaliation is huge as well. Another case, or a case that I wanted to talk about, which is still ongoing. It was filed, I believe, in 2018. It happened in the Old Town area of Chicago, and it's by the Old Time Triangle Association in Chicago, where a family tried to convert their garage and make it more accessible for their 14-year-old daughter. And when they attempted to do this, and they made this reasonable modification request, the president at the time of that association wrote a letter, and in that letter there was a lot of discriminatory comments that said, he didn't understand why, the family chose to buy a house in a neighborhood where they wouldn't have to convert something, or, and I think also in that letter in comments, it says, I don't mean to be heartless or uncaring, but this is the neighborhood. This is not the neighborhood for that. And you have to conform to our rules, not the other ways around. Very discriminatory policies. And so that family, of course, made a complaint. And that case is still ongoing, but that case was made in 2018, and that family is just now just last year, in 2020, was able to start making their needed changes so that their daughter could be able to access their home equally. So it's very disheartening, and it just tells you that even though laws have been put into place since the 1970s, there is still much work that needs to be done to advance rights for persons with disabilities. Also, I just wanted to briefly touch base and talk about Ohio's fair housing law. So it is unlawful to make any inquiry, elicit any information, make or keep any record, or use any form of application containing questions or entries concerning any protected class. So no rental applications should be asking a person whether or not they have a disability. So if a person feels like, so, just to kind of wrap it up, we talked about covered property, we talked about protected classes, and we talked about what sort of actions could take place by a housing provider that would be considered as discriminatory action. So if you feel like you have been discriminated against or you are being discriminated against under the Fair Housing Act, what do? Well, who can make the complaint? We are all members of protected classes and afforded the right to fair housing. If you live in the US, then you are covered under the Fair Housing Act. Where can a complaint be brought? Again, you want to be familiar with your local laws because some cities have fair housing boards, like the city of Cleveland has a fair housing board, but a complaint can be made with HUD or the Ohio Civil Rights Commission. If you feel like you are being discriminated against, you can definitely call our office and our advocates will walk you through that process. Who can be sued? Just about anybody, housing providers, maintenance staff, cities, just about anyone can be sued. And then the role of government is to enforce these laws, right? What is the purpose of having fair housing laws in place if they're not being enforced appropriately? And then the role of fair housing groups, so groups like our organization, again, is to advocate and assist individuals through the process to let individuals know what their fair housing rights are, but then also to let housing providers understand what their obligations are under fair housing. And then again, more so, what are the consequences? So lawsuits, of course, can be brought. Once the complaint and investigation, if probable cause is found, then there's an administrative hearing and damages could be awarded. Compensatory damages, punitive damages, and injunctive or equitable relief, and even suspension or loss of real estate license for housing providers. And so with that, we will conclude this presentation, and I will hand it back to Kayla so that she can offer us that conclusion.
Thank you.
Sorry.
It's okay.
It's not good. There we go.
Okay, so the goals of fair housing is to reverse decades of effects of discriminatory policies, foster inclusive communities, allow everyone equal access to the housing of their choice, because like we said, location matters, and increase diversity among schools. So the goal is equality versus equity. So in the first image, it is assumed that everyone will benefit from the same supports. They are being treated equally. Everyone has the same height crate, but everyone is also different sizes. So in the second image, individuals are given different supports to make it possible for them to have equal access to the game. They are being treated equitably. In the third image, all three can see the game without any supports or accommodations because the cause of the inequity was addressed. The systemic barrier has been removed, which is the overall goal of the Fair Housing Research Center. And how you can get involved, you can follow us on social media, call us or refer others to us for assistance, spread the word about fair housing rights, and get involved in your local fair housing advocacy.
Okay, thank you so much, Kayla.
Thank you.
And with that, we can look to see if there are any questions that we might be able to answer. I don't know how to stop sharing my screen.
We have a few questions that have popped up actually.
Okay, great.
All right, let's see. The first question says, can a residential contract between HUD and the leasing office decide that they will no longer accept Section 8 while a tenant is under lease? I had a situation where management decided they no longer wanted to accept Section 8 and was asked to move or be evicted after living there for 7.5 years. I was told they did not have to answer any of my questions as to why they would not renew my lease.
I am so sorry that you had to experience that. To my knowledge, and I can definitely check back with our advocates, and so I'll just write this question down. But to my knowledge, I believe that the housing provider has the right at any point to stop accepting the program, except for in cities that have source of income protections, right? So we talked about, I touched very briefly on source of income as a protected class. And currently there are just a handful of cities in this region in Northeast Ohio that has source of income as a protected class, including the city of South Euclid, Warrensville, Lindale, University Heights. The city of Cleveland is making great strides to include source of income as a protected class, but it's not a protected class yet. So to my understanding, a housing provider has that right to, in order to stop accepting a housing choice voucher recipient, with the exception though that it is in a city that has source of income as a protected class. But again, I can take that question to our advocates just to ensure, but to my understanding, yes.
All right, the next question is, can you provide an example of administrative burden, please?
So administrative burden might be, needing excessive staff members in order to be able to carry out the reasonable modification or reasonable accommodation requests, or spending excessive time. There hasn't been too many situations that I've seen personally, or that the organization where a housing provider was able to argue that it is an administrative burden. So I don't have a great example of that because I haven't seen where a housing provider has been able to successfully argue that this request is causing them administrative burden. So
Someone wants to know, do you work with Geauga County as well?
we cover parts of LaBraine and Cuyahoga County. We do not cover Geauga County. I can just look up and see. I think just our neighbor, the Fair Housing Resource Center, covers Geauga County for you, but I can look that up before we end. And am I able to, like, if I put something in the chat, is everyone able to see it?
Yes.
Okay. So what I'm going to, I'm sorry, what I'm going to just do real quick, I'm just going to provide my email in the chat. And so if people have specific questions, or if there's something that needs to be followed up on, you can email me and I will ensure that I will get you to the correct resources, or make sure I follow up with you. So for the person needing some assistance or wondering about Geauga County, feel free to email me and I can direct you to the Fair Housing Agency that serves Geauga County.
Great. We'll take one more question and then they can actually email you directly. So that way they can get that one-on-one time. The last question is, what type of providers can write an ESA letter to a landlord?
So medical providers, social. So again, with that reasonable modification request, it can be the medical providers, and then social service providers, and then anyone who just maybe intimately knows that person's condition and need for the emotional support animal.
All right. Well, I want to thank both of you for all of the great information. This was a very informative webinar. So I want to thank you for the audience, as well as for Services for Independent Living, for agreeing to partner with us. And I just wanted to let everybody know that I felt that it was important, besides it being Fair Housing Month, we definitely wanted to talk about fair housing and the act and everything, because it, the whole purpose is to ensure that nobody is discriminated against, in property transactions or on the basis of his or her protected class. So I hope everyone enjoyed this, and please follow up with Tanesha, and I want everybody to enjoy your day. It's a beautiful day out, and stay safe. We're not COVID free yet.
No, thank you so much for having us. Appreciate you having us today.
All right. Thank you, everyone.